We are delighted to welcome for the first of a series of 3 podcasts, Mark Collett. Sheena will introduce Mark in a moment, but I'm sure his name is familiar to many of the viewers. But I just wanted, before we turn to Sheena, I just want to just set a bit of the background of these 3 podcasts. The series is called The Brave Step, which relates primarily to the step taken by the Gauteng division in respect of its protocol and attempts to deal with the civil procedure crisis and particularly access to the courts. We're going to break that series up into 3 episodes. Episode 1 will be the courageous rationale, tackling the civil justice crisis head on. And this is episode 1, so we'll deal with that topic tonight. Then episode 2 is mediation, the solution for efficiency and quality justice. We'll deal with that in the next podcast. And the last podcast will be episode 3, the necessary institutional shift and collective responsibility. I must say, I'm really looking forward to this. I think it's going to be very informative and enriching, and I'm very interested to hear what Mark has to say. So without further introduction, I'll hand over to Sheena to give you a background to Mark.
Thanks so much, Ian. So yeah, it's an honor to have you on our podcast, Mark. I've actually known Mark for 20 years, and I know him as a brilliant mediator himself. So he's a very highly experienced mediator. And just to give you a little bit of his background, he has qualifications in business administration as well as social work. And I think one of those is a master's in dispute resolution. Am I right?
Yes.
Yeah. So he brings a uniquely integrated perspective to the field of mediation. He's been a very prominent figure in the development of South African mediation standards. He was a founding member of both DISAC and NABFAB. So Mark's commitment to advancing the practice of mediation is underscored by his research master's degree. There it is. I preempted. I jumped the gun. From the University of Stellenbosch, where his work was cited in the South African Law Reform Commission Project 100D. This project focused on ADR within the family setting, highlighting his specialized knowledge and influence. So he combines his practical experience as a long-time mediator with a deep understanding of technology. And can I say that you are part of the ADR Tech group?
Yes,
I am. I've just said it. So the horse is bolted.
Well, unless it's edited out, I guess it's in.
Yeah. So I think your experience in legal tech adds something valuable to the whole industry. And I think that ADR Tech has been at a grassroots level, you know, with this whole directive coming into being. So I think that when Mark talks, we should all listen. We're going to get a lot of information from him tonight. We might drag some more out of him.
Within this 3-part series, Mark, you know, the Brave Step, which, as anybody that is even remotely involved with mediation is aware, is you know, we're at one of those potentially crucial junctures in the development of mediation in this country. And the reasons why we call this 3-part series The Brave Step, I think, will become apparent over those episodes. But let's just start off with episode 1, which is the courageous rationale and tackling the civil justice crisis head on. You know, I work in the courts regularly, and I have for 30 years or so. And you know, I've always been aware of a problem of access to justice, but it has become at a very real coalface level, increasingly apparent to practitioners that there's something very seriously wrong. But I think you're going to give us a lot more detailed insight into that. And I think I can just start off by saying to you, what is it that led to this the brave step being taken? What exactly do we mean by that brave step? And just give us a little bit of an introduction to that, and then let's just take the conversation from there.
Yeah, thanks, Ian. Yeah, and thanks for having me. I think it's multifaceted and it's complicated. But I think in the shallow end of the problem is just the delay. So, and I think it's useful to take the view of a client, someone seeking justice. So yes, you've got the legal practitioners, but the legal practitioners are representing someone, and I think to think yourself into their story, because we are there for those people seeking justice. And pretty much, if you think about any category, so whether it's personal injury, commercial, civil, you can think yourself into a scenario, and in that scenario, you've been wronged somehow, or you're looking for some sort of compensation. There's normally a process, some formalities that need to be gone through in the initial phases of the legal process. And then even once you've jumped through those hoops, you'll be told, if you're lucky, that you've received a trial date that's in the year 2031, if it happened 4 months ago, if you were ready to get a trial date 4 months ago. You are then in limbo for those years. So for 6 or 7 years, you are waiting for your day in court. And for personal injury, people that have suffered personal injury, that's serious, because any adaptation that they would need to make to their living arrangements and so on to carry on is paused for 6 or 7 years. In the commercial setting, businesses are waiting for some sort of compensation, or for some sort of adjudication for 6 or 7 years. And there are very few businesses that can carry a serious knock like that. If it's cash flow that might be threatened and so on. So one can move from one category to the next and see the problem that's created by a delay in getting a trial date. So that's the first question. And we're not alone in the world, by the way, there. Countries like India reportedly at one stage had something like a 60-year delay. And you would wait for 60 years because many of those claims were land claims. So you would go to court, your grandparents would have instituted the action, and then it's still worth going to court, or because you might score land at the end of it. But that is
Well,
serious.
I mean, all I can say about that, if anyone is familiar with about Charles Dickens's Bleak House and the infamous case of Jarndyce and Jarndyce makes Jarndyce and Jarndyce look like an urgent application, on a
he
photo.
knew nothing. He knew nothing.
Yeah.
So that's and for me, so even the work with the ADR technology group that we do, and what our focus is from supporting it from a technological perspective, we always bring it back to the person that we're seeking to benefit in this is that person that's seeking some sort of justice. And the crisis, the reason I believe for the judiciary acting was that they recognized the crisis, and it's been this elephant in the room for years. And that was looming large, and I think it was brave to admit that there was this elephant in the room. The other big aspect I think that counterbalances that is pilot project after pilot project where mediation was experimented with in different settings, like the Road Accident Fund, like the court-based mediation in the magistrates' courts that ran, probably 13 years ago now. Those pilots are successful. So what you've got on the one hand is a horrible backlog. On the other hand, you've got mediation as a form of ADR that has proven itself in the pilots, and it becomes difficult to ignore the year's delay. And on the other hand, it starts becoming difficult to ignore the success of mediation. And so that starts creating a compelling argument to then move forward with mediation. But what makes it courageous is that we've got a whole legal system that's that's built on an adversarial way of engaging. And so we're sitting with a legal fraternity, and even the clients, the parties have an expectation of a fight. And so we have a legal fraternity who's trained in that adversarial process. In other words, leading arguments in front of a presiding officer who will determine who's right and wrong at the end of the day. That method is very different to negotiating and influencing. And so it becomes courageous to make a call for mediation, despite the elephant in the room of the delay, despite the evidence of the pilot projects. It becomes a courageous call because you're sitting with a legal system that's well trained in an adversarial process. And so what you would expect is at least a perception that you've gone anti-establishment, and you're making this maverick call against the legal industry, and it's because of years of practice in a certain way, and that's why I think the call of the judiciary was brave.
And also, Mark, and entrenched within that paradigm, that adversarial system paradigm, an entrenched model of reward for certain behaviors and skills and structures set up or acquired sometimes over decades. And so the legal profession, I think to an extent justifiably, has some concerns and reservations about the step. The reservations, whether the solution emerges or not, is something which we wait and see. But just to add to that, I've said before, and I'll say again now, that to my mind, the introduction of Rule 41A and now the protocol, which is effectively giving Rule 41A teeth. I've said two things about that which are relevant to the conversation at this point. Firstly, that Rule 41A, largely for the reason that you've set out, which is that it's a completely different approach to resolving disputes, would not get traction unless and until it gets the imprimatur of the judges and the considered weight of the judges behind it, and that the judges actively promote Rule 41A. And I believe that in the intervening years that's proven to be correct, and we will see now whether in fact, once the judges now come on board, whether that is going to propel mediation into some sort of accepted method of resolution. But that's the one point. And the related point is that, to my mind, the introduction of Rule 41A and the concept of mediation is the most revolutionary and far-reaching alteration to the South African civil procedure in the High Court specifically, but more generally to civil procedure, that we've ever seen, because it sets up this parallel system of resolving disputes. And if you're going to make such a fundamental shift, you can expect that there are going to be some entrenched interests which are opposed to it, and you can also expect, I think, some legitimate concerns about how this is going to work in practice and whether it will be effective. But I think those 2 points maybe are worth making to add to what you've said, Mark.
Just before you go on further, Mark, I just want to say, while we're talking about adversarialism, is that litigation was always designed for outcome, and it was obviously a progression from the bare knuckle fist fight or the sword fight at dawn. So it was a progression in human consciousness, but it was specifically designed for outcome, not dispute resolution. And the complexity and the artificiality of the rules of evidence and procedural rules and that kind of thing make it such that it's difficult to get to outcome. You can get to outcome in one court, and the other party can drag it to another court, all the way up to the Constitutional Court. So that's the one thing. It's not it's not dispute resolution. It's not there to resolve the dispute. It's there to bring the dispute to an end. And that's not even happening because of how the courts are so hamstrung. And access to justice is one of the cornerstones of our legal system. And the fact that we're having to wait till 2031 to have our matters heard it impinges on that. But I also, while we're talking about adversarialism, as a social worker, maybe you can just comment on this. Like, and I think we'll probably get more to this in the third section where we start talking about our collective responsibility. But the way litigation is done is you go into a lawyer's office, and the person that you're in dispute with must necessarily be cast as your enemy. So there's this whole enemy conscious around the system that actually makes the whole thing brutal. And if you add to that the fact that you have to cast this person as an enemy and then prolong this like it's a chronic, like slow burn enemy over like 10 years or whatever it is.
Best kind, yes.
You know, if you think about like a commercial dispute or a family, I've had contact with many family disputes that have spanned 10 or even 15 years or whatever. But that's that adversarialism that's baked into, and it's not just the legal system, by the way, it's all our social systems, it's economics, it's politics, it's everything. And I think that the courage within this also inadvertently is a moment for us to pause and reflect on how we're doing in society, and to shift our focus more to problem solving than to like, I must overcome you, I must be right, I must win this. No, let's see if we can do this together. And lawyers are intrinsic to that because lawyers are problem solvers. But it's a shift in focus. And in fact, there's an entire international problem-solving law movement. So yeah, just while we're talking on adversarialism, maybe weave some of that in, and your thoughts on that.
The lines are so blurred. The lines are so blurred because part of what we might be talking about here is the efficiency of the justice system. And it looks like that, you know, so it looks like cold numbers, and there needs to be a way to unclog the courts and move matters through. But yeah, and when we talk numbers and efficiency, it almost comes at the exclusion of thinking about the human experience. And my belief is that it's actually tied up with the human experience. So good outcomes, good settlements that don't keep coming back into the justice system are settlements and agreements where there's been a proper meeting of minds, and I want to say in brackets, hearts. So
yes,
and a lot of that conversation is excluded from a courtroom. So the forum doesn't seem right. Now that's borne out in the preamble in the directive, where, and this is why I'm quite a fan of the directive for how it's just cut through a lot of the rhetoric that's fairly academic. The experience of the judiciary is that 85% of matters that are on the roll, on the trial roll, do not actually be heard. So 85% are not actually, trials are not actually being heard, and they cover that in the preamble. So even though we can get quite and I think we can justify the operations of the legal system as if every trial goes to trial, and actually we're talking about 15, maybe 20% of matters where the trials are actually being heard. and so I think that changes things a bit. So if you balance, so what's really going on in our law, what's really going on is that only 15% of matters are actually going to trial anyway. So you've got 85% of matters in the High Court where they've knocked on the wrong door, and they're settling anyway, and so that need for an adversarial platform, the need for adjudication, the experience of the judiciary bears out that it's only necessary in 15 or 20% of the matters. So
and
whatever
that's
the other
something,
argument you make.
yeah. That's something Prof. Farris from UNISA, he's not there anymore. I think he's an editor for LAWSA now, but he used to head up the Center for Dispute Resolution in Africa. And he was saying 20 years ago, courts in South Africa are symbolic. 80% of matters are do not go to finality in court. And he was saying it's less than 20% now, but you're saying it's even worse than it. It's 15% maybe. Yeah.
And it's not me. That's coming from the judiciary, in their preamble to the directory. So that okay. So that's the hard numbers side of things. So what the judiciary are saying, I think, in this directive is, can we please be honest and call it as it is? And when they're calling it as it is, that's how it is. Only 15% of matters are actually being heard at trial. But then the gray part, I think, starts coming in where it's the human side, not just the working of the legal the legal mechanisms. And it was a conversation that I had with a JP, not in Gauteng, and what she was saying is her desire, and this had been her experience. Her desire was that mediation, and the mainstreaming of mediation would give parties the opportunity to tell their story, and being given the forum to tell the story, that they would be satisfied that they were heard and justice was done. And her concern was that our courts at the moment were not set up to allow people to have their stories heard. So even where mediation is partly settled and there's some matters that go to trial, her feeling was that, okay, it's back in court, but the issues are narrowed, and also the way that the parties deal with each other when they arrive at court, having had the opportunity to tell their story, is very different. And again, I say it's grey, but then I think back to CODESA and the negotiations that were happening in Kempton Park. We as a country, we got kudos for that process. And I think in some ways, the history books have sanitized that process, and we go, oh yes, it's beautiful. Like it was negotiated with the country's interests at heart. You can pick at some details, but people for the most part engaged in that. And the way that we've looked back at it, I think we've romanticized that a little bit. There was a tank that drove through the reception of the meeting room, and
the trade center,
the trade center, and the conversations that happened were emotionally charged, high stakes, and something kept us as a nation. Something kept us in the conversation, even though it was hard. And there's something about this that the judiciary's brought in that, for me, has that flavor. It's new, it's difficult, but what we're doing is we're backing us as a country to be able to have the hard conversations. And it's not about tricks of influence or bullying, or some sort of procedural tricks that we might play to win over the person on the other side, because we even talk like that. So the other side said this. And it comes back to what you were saying earlier, Sheena. It's like an adversarial process requires us to demonize the other side and not to empathize too much. But in the humanizing and the empathizing is the generating of creative solutions. And then suddenly we've got a nation who's prepared to talk to each other, even when it's difficult. And so I think the CCMA has had some success with that. And you see how the reduction in matters at the Labour Court, and this is brave because the scale is massive. Going into the High Court, but what you're introducing is a way of dealing with conflict and difference as a nation that respects the other person and respects our society as a place where you can have differences and you can work through them without resorting to violence. The tank coming through the window, aside. What happened at CODESA was a kind of prototype of how we could be like as a nation. And I think by bringing mediation in, I'm heartened by it.
All right, Mark. I mean, that's all interesting, and it is interesting thing of these parallels and particularly this bigger picture. It's a thread that I'd like to pick up, which relates to that is, and this is a particular concern which I have, I suppose, maybe thinking about these sort of national effects of the national effect of putting a process like this in place. But with that delay comes a very real erosion of the rule of law. I've become increasingly concerned about, even in this conversation now, there's discussion about the judicial system simply being, what was it Sheena said, a facade, or
no.
What was it?
I said courts are symbolic in the sense that
All right, so that's worrying. And that I'm not criticizing the comment. I'm criticizing the fact that led to the comment. And maybe Mark, you want to comment on that?
My initial response is that there's always a place for law, obviously. So there's a place, and I think there's
you mean litigation, not law, because
or litigation.
that's right.
That's right. So and I'm talking about the courtroom. So there's a place for judges to make adjudication, or presiding officers in general to make adjudications in certain matters. And I think for whatever reason, the pendulum has swung a bit too far, and this is a pendulum coming back. And Ian, you made reference to it earlier. I think for the pendulum to come back, it required decisive action from the judiciary. So it requires, you called it an imprimatur, but it requires some direct involvement by people involved in that system to bring that pendulum back. So I guess I hesitate giving an answer because I'm not all. I don't feel like I'm anti, or I know I'm not. So I'm not anti the legal profession. I'm not anti arguments in court. What I think is required here is a balancing of getting the correct conflict resolved in the right place. And that's the backlog is a symptom of that. We've got the wrong conflicts queuing at the doors of the court, and the evidence is there, as I said in the preamble. So yeah, so for me, I'm not an advocate for getting rid of lawyers and getting rid of the legal profession. I think there's definitely a place for arguments. There's definitely a place for our legal system.
Well, I mean, I think
say
sorry, Sheena, can I just come in? Let's respond back to Mark, and then maybe you can come on your point. So what I'm taking from this is I think, and it makes a lot of sense to me, and even from a practical perspective, is that I really liked when you said that you've got disputes sort of knocking on the wrong door. Makes a lot of sense to me, because my view on it, and I think this would be a fairly widely held view. I mean, I speak anecdotally, but my view on it is that the courts play an absolutely critical role. That there are certain disputes which need judicial adjudication. That it's critical for society that there is that final measure if you need to go there. But as you pointed out, with 85, I actually thought 85 was a conservative percentage. But anyway, sure. Let's go with 85% of matters are settled out of court. Therefore, 85% of matters, and when they settle, incidentally, they're settled in a fairly ad hoc, unstructured way, sort of fast and loose approach. Litigators get quite good at a certain form of settlement, but it's nowhere near the type of standard which one would get for a settlement with a proper seasoned mediator overseeing the process. But anyway, so 85% of matters settled. One from a practical perspective, a phenomenon that I've observed over the years, which is actually very interesting, and I think something to bear in mind in this conversation, is that it's amazing how through the sort of like the pressure of work and the volume of work, if you can just get any matter within the sort of spotlight of the various parties to that matter, how high a chance there is of settlement simply because you've got minds focused. And it doesn't matter whether it's a block booking at the RAF or whether there's some other procedure that comes up which gets parties to properly focus on the matter, or, as I've seen in that RAF pilot project, mediation. Once the parties have applied their minds to a matter, there's some sort of sanction if they don't follow through, so they can't just ignore it, they have to try. And then come to the table, there's a very high percentage chance of reaching some sort of decent solution. So my thinking is that that 85% clearly that then goes into the, let's say, the mediation stream, or some other way of resolving that dispute stream. The 15%, which is properly litigious and which requires the attention of counsel and judges and what have you, let the courts deal with those matters. But why are they getting gummed up with matters that are not suited for the courts? Sorry, Sheena.
And that's exactly, So that's really the purpose of the directive. The judges are trying to say, just coming back to what Mark said, less than 15% of matters are actually going to trial. Let's be honest about this, and let's find a mechanism to filter out what needs to go to trial and what doesn't need to go to trial. And I just wanted to also amplify Mark's comment earlier that this is not about resistance to the legal profession, because the legal profession will be required just as much in the forum of mediation as it is in litigation, because I'm talking specifically about the mediation of legal disputes. It's a different forum where you are coming to try to persuade the other party rather than trying to persuade a judge. But there is advocacy required in that, in preparation, in understanding the complexities of the law. So I would really encourage the legal profession to look at this. This is a different forum for you to go and advocate for your clients. This is a more accessible forum, a quicker forum. I remember mediating an RAF matter in 2020 where the accident had taken place in 2003. That was a serious head injury case. It's unfathomable that we should be leaving victims of accidents for 17 years, and I think she was 19 when this accident happened. So these are the real things, and the judges have taken this brave step and said, let's be honest, not every matter that is going through the motion in the court system needs to be here. Let's find a quicker way for everyone to get paid and get their solution and be happier.
The applying of minds, I think that's a really, I think it's a useful insight, because it's something that we're seeing with matters being loaded on our platform, the ADR TG platform, where initiating parties are keen for mediation, and the responding party might be keen, but they're not ready to apply their minds. So in any other matter, they've got time. So you'll apply your mind in a couple of years' time, and the matters that came to your attention 2 or 3 years ago, they're coming to a head now, and you apply your mind there. With this directive and practically mediation being required to be done within 30 days, it's just forces that application of minds early in the process, and we can see it's catching people by surprise. So even though we're a platform where people are loading their matters and we're allocating mediators, we are having to remind responding parties that the clock is ticking. And so despite the fact that our platform is sending reminders, we are picking up the phone to say, are you aware that these timelines apply? And that is foreign. So in a world where everything is so delayed, that application of mind can wait. So you've landed the matter. You know that you're the attorney or advocate on record, and we'll get to it eventually. But the pace of mediation is quite different, and the big place where we see it is when you're being asked, as the person advocating for your client, you're being asked to apply your mind early in the matter. So pretty much it's landing on your desk, and especially if you're the responding party, the plaintiff might have issued an amplified 41A notice, identified a mediator, and then you need to get on the horse, and we see that's a new. The pace of it is new, or actually cadence is probably the right word. The new cadence in mediation is quicker, and the application of mind to what's really going on has to come earlier in the matter.
I'm actually finding, Mark, and I think Judge Davis referred to this as one of the kind of inadvertent results of this directive, that other matters would suddenly start being settled. So as an RMO, as ADR Network SA, particularly over the last few weeks, we've had so many matters come in where only a summons has been issued, because we'll obviously ask for the amplified rule 41A. No, that hasn't been done. It's an early stage. There's not much before the court. It's just the summons and particulars of claim. But we phoned the other side, and they're cool with mediation.
Yes.
So and also other provinces are phoning and saying, look, we want to act accordingly. Yeah, we want to try. We've said to our clients, why don't you try mediation here? So and I think a lot of that energetic is going to grow and gain momentum, and as people gain confidence around this thing and start seeing actually this could be good. Yeah.
I think that's important, Sheena, especially from the legal, speaking to legal practitioners, and, it's something that struck me over the last few years is you can almost divide the attitude of legal practitioners into two groups. And it's those that have trained as mediators and those that haven't. and the ones that are trained as mediators are pro, and the ones that haven't are anti.
Yeah,
And
yeah.
I mean, it's remarkable. And you know, I do think that an important component, speaking from as a legal professional, and speaking, you know, for my colleagues, if I can be so bold, but an important component of it is whether the system is going to work. And that is a narrative that does seem to now be emerging, and there are frustrations along the way. But ultimately, the question is it going to work in practice, and will it be everything it's promised to be? And if it does, then you'll get increasing buy-in, I'm sure. There's not an innate resistance. It's a question of, you know, practically, is this going to be another impediment, or is it going to be a solution?
Absolutely.
There's resistance from one, I want to say group, from one quarter where that I think is legitimate. And again, like I tend to personalize this so because we're servicing people, and if my trial date was coming around, and let's say it's a road accident fund matter, and in 2023 I managed to get a trial date for February 2026.
Exactly.
And then on the 22nd of April 2025, I've been waiting a couple of years, and I've still got nearly a year to wait for my trial date. And we managed to book whatever, the 3 days in court. And on the 22nd of April, actually, I probably got the phone call on the 23rd of April from my attorney to say, sorry, we've been struck off the roll. Damn.
Yeah. And
that's not great. So,
it could be devastating.
I think, so the transitionary period that we're in now, the road accident fund matters require mediator reports, but they haven't suffered the drama of losing their court date. But what happens in road accident fund matters at the beginning of, well, it's happened. Anyone that had trial dates from January 2026, those dates are lost. And again, like when I think about victims of car accidents and so on that have been waiting that long, they would look at this mediation directive and curse. And so there's a generation of matters where I'd have to say, sure, this does look like an injustice. And so Ian, when you're talking about, is it working? There are a whole lot of people that are on the court roll at the moment that I know which way their vote would be. They'd be going, this does not work. I've been waiting for years, and now I just lost my and it's this new thing. I don't know where to go, and now what's going on. Thankfully, there aren't long queues at mediation, so the mediators are picking it up. We don't have the same formalities as either arbitration or court procedure. But so the movement's there. But if I'd been waiting years, I would be skeptical. Hey, and so there's that. So there's almost like a sacrificed. There's a sacrifice group that thought that they were going to get their trial dates. So they saw it in black and white, and suddenly they saw it disappear before their eyes. And I would expect there to be some emotion. They also get caught by the mediation, process. But yeah, no, I can understand the angst and anger even if I'd been waiting that long and I lost my date.
Absolutely. Absolutely.
The other aspect of it, Mark, is and I sort of touched on it earlier, but since you've given that answer, maybe I'll just develop this slightly, is the fear that this becomes just another impediment towards where you find your real result, which is in court. And there are the background to that fear is not unjustified. In other words, there's the experience, particularly from amongst RAF plaintiffs' attorneys, of what they would say is an abuse of the system, or a, certainly, let's maybe not put as high as that, but a non-compliance with the system to the benefit of the defendant who may want to drag their feet, right? And a sense of frustration with well-established procedures, such as obtaining expert reports or having pretrial conferences, and all those laudable pretrial procedures can then become corrupted and become an impediment towards your day in court. And a lot of the concern that I hear within the legal profession comes from that experience, because there's bitter experience over the last decade or so of having to go through that, and not only, and we're talking about some abstract notions of the rule of law and the acceptance of the judicial system, but you must remember, from the perspective of a legal practitioner, that's your bread and butter, that's your practice. And then suddenly you get this additional potential obstacle put in the way of arriving at court, where you've got some proper leverage finally when you're before a judge. You finally got, you can say, well, either settle or we're running the trial. And finally you've got that. And now suddenly you have this extra hurdle you have to get over. And it's not just one. Now it's emerging that there's several applications that have to be brought. And just to finish on this particular thought, there was, it's actually worth reading the case law relating to when serious injury assessments were brought in. And with hindsight, with respect to naivete of the Supreme Court of Appeal, when they said, well, surely you wouldn't ever have to deal with these sort of rats and mice interlocutory applications. Just one or two of those applications with an appropriate attorney-client costs order will be enough to ensure that the RAF does its job in assessing the seriousness of the injury timeously. And experience has taught that fear was very well founded. And there's that sort of institutional memory within the legal profession that I think runs very deep.
I think there was there's an interesting precedent. The Italians have gone before us with mandatory mediation. I think it was around 2012 or so, and it was, mediation there was phenomenally successful in its first year. 128,000 mediations heard
Wow.
in the first year. Very, very successful. But then it was taken to the Constitutional Court, and it was a similar argument to what we saw here, and it was seen as undermining people's access to justice, forcing them to mediation. And the opinion of the Constitutional the eventual outcome was that they defined the categories. So certain categories of mediation or of litigation required mediation. But
so categories, as in what types of case? So, for example,
yes, so you would say like family and divorce,
right? Okay,
right, similar to our mediation bill. So,
right.
But what one of the things that they said is that applying mandatory mediation in itself does not constitute infringements of people's rights, to the access to justice. But if by implementing that step, they were forcing people to queue in a different queue, and then that might be as long as the queue to enter the court, and then you're asking them to once they've queued there and they've got their mediation done, then you come and join the queue that you've just left, and you're joining the back of the queue that you just left to go and queue somewhere else, and that to them constituted an infringement of people's rights. So you can't, adding a step in itself is not denying access to justice, and especially where you might get a settlement rate of, would peg the goal at 85%, but even if it's 50% and you're offloading half of matters in the court, it just kind of potentially halves the waiting time if you need access to court. And so adding the step in itself, they didn't see as offensive, but adding another queue is offensive. And so the efficiency of how those mediations are handled, that you've got enough mediations, that you've got a platform that's moving those mediations through, becomes critical, because that's what your the right to access to justice kind of spins on. Don't go and join another queue that's as long as the queue that you were in order to come back to the long queue. That's just a nightmare scenario.
Yeah, that's very interesting, Mark. And yeah, so that becomes a sort of factual issue as to, how efficiently is the mediation queue moving, and how, to what extent is it shortening the litigation queue. So those are fascinating sort of spin-off thoughts, and that's part of, we'll have to see how that works. Because I know that's right. One of the concerns that expressed by the legal profession is, are we just adding another queue? I think you put that quite well.
Yeah, and that's something that we need to guard against.
Yeah, no, absolutely. So I thought, Sheena, you wanted to make a comment?
Yeah, so we were going to come as a final topic on this to drawing on international success. So you've spoken about Italy, and I was actually going to say, hey, don't give the resistors to mediation in courts ideas here. But yeah, you've done it very well. You've said it out very well, and I'd actually like to hear more about the Italian example. Do you know how mediation is going there at the moment?
Yeah, so well,
having categorized.
Yeah, I haven't seen the numbers recently, Sheena, but it's a bit like, when there's no smoke. This is probably misquoting them. When there's no smoke, there's no fire. Maybe that's not true. But the international comparisons are not, when you scratch the surface, international comparisons are not that easy, by the way, because in many jurisdictions that we talk to, so as South Africa, we talk to India, we talk to the rest of Africa, and even in court annexed mediation, their goal is reconciliation. And we are friendly, but we are not that friendly. So we wouldn't be trying in our system, we wouldn't be trying to convince a couple who intends to get divorced. We're not trying to convince them to reconcile. And that actually is the case in many jurisdictions that have mediation. So the mediation is to bring peace and have them get back together. Now that's not how we see it. So what is common internationally is that the settlement rate of mediation and facilitative mediation in particular is high. Like, we know that, but it requires a bit of a scratching of the surface to understand what is it that people are looking for. So we're not far from how the Americans would approach it. So in California or even the Norwegians, but the understanding of what mediation does, you would have to look a bit more closely. So, for example, in Gabon and Malawi and so on, it's a bit of a different understanding. Their success rates are still high, but it's a different understanding of the goal of mediation than we might have, and we just assume it when we see the numbers.
The other point about it, and maybe the Italian example can serve here, but it begs the question. So the first thing is that you have to understand that system accurately, which is what you're describing. And then once you've understood their system accurately, all right, let's say it points to this two queue problem, right? Right now we understand the problem, but it still begs the question of, well, what's happening in South Africa? And how efficiently is it being applied here? So now we understand that's one of the things we've got to check. Now you've got to bring it back to South Africa and then understand the South African problem. And I'm quite sure that if that was a problem factually on the ground, procedurally, if you like, in South Africa, that would just be self-evident. So that would emerge in the litigation anyway.
That's right. That's right.
So Mark, in our next episode, we're going to be chatting about mediation actually being a viable solution to this crisis, and we're going to drill down more into efficiency and quality justice. I think this is a really good start of a discussion, and a drilling down into just how brave this step has been, and also encouragement to all involved to actually undergird this step and to support it. And so next time we will be looking into mediation as a solution for efficiency and quality justice, or one of the solutions, or one of the appropriate solutions, as we said, depending on what the case is and whether it is really right for trial or not, or right for litigation per se or not. Any further thoughts from you, Ian? And maybe
I just want to thank Sheena, both you and Mark, for I was hoping be an absorbing conversation. I found it really interesting, and one of the lessons as a litigator that you learn as soon as you're trained in mediation, and you're always reminded of this when you engage as a mediator in mediation discussions, or certainly I am, is that we as litigators we're very entrenched within a particular process. And interacting, and maybe this is also a word to the litigators, interacting with mediators allows you to realize that there's that view is only one sort of slice of the overall picture. And I've always found it so interesting to engage with mediators, because they come with a completely fresh perspective. Sometimes certainly not such a secure handle on the litigation. But that doesn't matter, provided it's good enough to get them to the point that they can then exercise their skills, experience, and perspective. And it's in a sense quite intellectually humbling, because the solution that litigators believe so deeply in, or should believe so deeply in, for whatever reason, turns out maybe not to be such a good solution in particular cases, and possibly even in the majority of cases. And so I've again found in this conversation an interesting sort of shifted perspective, and then also just an enrichment of the general understanding of the process and the broader picture. So to Sheena and to Mark, both of you, thank you very much for your engagement, your input, and I found it tremendously enjoyable. Mark, I'm looking forward to the next 2 episodes as well, and thank you for your time. Yeah,
thank you.
Thank you for having me.
No, it's been a real pleasure.
Thanks for coming on. Thanks, everyone.
Good. All right.
So
good.
we'll see you at episode 2. Cheers.
Yes.
Yeah.
Excellent.
Thanks,
right.
guys.
Good. Look forward
Cheers.
to it.
Bye.
Cheers. Bye-bye.